want everybody to be able to vote and express their own opinions. We have developed this voting rights symposium in hopes of really educating lots of people for what's coming up this fall in the elections and beyond that too.
Welcome, everyone, to Pioneers in Public Interest, the Battle for Voting Rights 2020. Thank you for being with us virtually today as we launch this inaugural conference honoring our Public Interest Law Scholars Program. Today's conference was the brainchild of Honorable Nani Burns, class of 1977 and 1978, our lead supporter of the PILS program. Nani is a trustee emerita for Northeastern University and our conference chair for today's program. And I'm sure she'll tell you more about the PILS program later. Of course, we hope today's program will be in person at Northeastern, but the silver lining is that we have people joining us from across the nation. We are very pleased to have partnered with Northeastern University's College of Social Sciences and Humanities. And you will hear from COSTAS PANAGOPOULOS in a bit, and the Center for Public Interest Advocacy and Collaboration, and the New Law Lab, who is working on an exciting project that COSTAS will discuss. With the November presidential election looming as perhaps the most important election in our lifetime, unpacking all of the impediments to voting and our nation's history of voter suppression and intimidation, threats to polling booths, particularly for people of color, is critical. Today's discussion will reflect cutting-edge scholarship and inspirational strategies for how we not only engage in the battle for voting rights, but also win. Nani and our development team, Megan, Miel, and Jennifer, have pulled together a stellar group of national experts on voting rights topics. And we're fortunate that they are joining us in this conversation today. To begin with, we have a special presentation from COSTAS, who is a department chair and a professor of political science. He's been partnering with the law school's New Law Lab on an exciting app that he'll tell you about. Following COSTAS, we're truly pleased to welcome Dale Ho, Director of the Voting Rights Project at the ACLU, as our keynote speaker, and we look forward to hearing his insights and opinions on voting rights. Some of you may be aware that Dale has recently been featured in a documentary entitled The Fight, alongside two Northeastern law graduates, Bridget Amiri and Chase Strangio. Now, that's a film worth watching if you haven't done so already. Additionally, we're honored to have Alan Solomont, Pierre and Pamela Omidir Dean at the Jonathan M. Tisch College of Civic Life at Tufts University, serve as our moderator for our panel. Our experts include the Honorable Anita Earl, Associate Justice of the North Carolina Supreme Court, Moon Dutchin, Associate Professor of Mathematics and Tisch College Senior Fellow at Tufts University, our own Rasan Hall, class of 1998, Director of the Racial Justice Program at the American Civil Liberties Union of Massachusetts, and Michael Lee, Senior Counsel for the Democracy Program at the Brennan Center for Justice at NYU School of Law. Michael previously joined Michael Dukakis for a panel for us in the past, and we're so pleased to have him back at Northeastern. Thank you all for making time in your busy schedules for today's important conversation. Now, it's my pleasure to introduce you to Nani Burns, Trustee Emerita, our conference chair and the founding supporter of the Public Interest Law Scholars Program at Northeastern University School of Law. Nani's career is impressive. She served as Commissioner of the Massachusetts Division of Insurance, and before that, she was an Associate Justice of the Superior Court of Massachusetts for more than a decade. While on the bench, she served as the chair of the Gender Equality Advisory Board and the Jury Management Advisory Committee. Prior to her appointment to the Superior Court by Governor William Weld, Nani was an attorney at the firm of Hill and Barlow. Nani has also honored the law school with her wisdom as past law school commencement keynote speaker and has served as a university trustee. In recognition of all that she has accomplished, Northeastern bestowed upon her an honorary doctorate of public service in 2007. Nani, thank you so much for all of your hard work on today's conference. Now, it is my pleasure to turn it over to Nani.
Thank you, James, and thank you to everyone in the audience for joining us today. We at Northeastern began talking about a voting rights conference well over a year ago to honor our Public Interest Law Scholars Program. The PILS program, as it's known, was launched in 2003. Northeastern is well known as one of the top public interest law schools in the nation. The renewable, full tuition public interest law scholarship is offered to exceptional applicants who possess impressive academic profiles, as well as extensive experience in fields concerned with social justice and public service. We hope that these scholars will be further inspired by their education and experience while at Northeastern to carry forward their public interest work. Many scholars have done just that. As James mentioned, we're truly grateful to our terrific lineup of speakers today from across the nation. Voting rights is a topic that I care deeply about because it is fundamental to our democracy. Voting is the one opportunity that every citizen has to participate in their government, and we want to make sure that that opportunity is realized. Today, we hope to elucidate some of the recurring impediments to voting rights and dive into how we can take action to ensure the integrity of the voting process. I'd also like to thank James, Luann Kerwin, and the law school's alumni relations and development team, including Megan, Miel, and Jennifer, for all their hard work pulling this conference together during challenging times. It is now my pleasure to introduce Professor COSTAS PANAGOPOULOS, Department Chair and Professor of Political Science for Northeastern University's College of Social Sciences and the Humanities. COSTAS will discuss techno-voting, using app technology to bolster voting convenience and participation. COSTAS, we're so pleased that you could join us today and look forward to hearing some of the work you are involved in.
Thank you so much, Nani. It's great to be here today and to have this opportunity to talk with participants about our really exciting new collaboration, the Time to Vote project here at Northeastern. This is a collaboration between the School of Law, the Center for Public Interest Advocacy and Collaboration, the Civil Rights and Restorative Justice Project and New Law Lab, and the College of Social Sciences and Humanities that I'm a part of, the Political Science Department, and the Dukakis Center for Urban and Regional Policy, along with our Charlotte, North Carolina campus and the leading social good app developer Quadrant 2. We've worked together to develop a phone-based app that will allow voters in North Carolina and Arizona to collect information about the voting wait times and other challenges they may experience when trying to vote in November 2020, whether they vote by mail or they vote in person. So this information will allow us to study and understand how long people wait in line in these places, whether or not those voting wait times affect whether or not they ultimately cast a ballot on election day or just give up and go home, as well as how other things like resource allocation to precincts in different places, and also if there's racial or other demographic group disparities in some of these features. So we believe this is important work. It's been work that's been going on for a few election cycles and work that we hope to contribute to. And it's also a great opportunity for us to use technology to let voters accurately report to us themselves how long they voted in line to vote and other aspects of their voting experience so that we can understand it better and really contribute to this literature and to help elections officials and administrators do their jobs better and make it easier for people to vote so that we don't have huge levels of voter disenfranchisement attributable to things that can very easily be fixed, like allocating more poll workers to certain places or more voting machines to certain places. This stuff is very important. We know, for example, from studies that have been done, that for every additional hour a voter has to wait in line to vote, their probability of voting in the subsequent election drops by 1 percentage point. Now, that might not be, it might not sound like a lot, but when you multiply that across 200 million voters in the country, that can actually be consequential, especially in very close elections. This is important stuff, and it can very easily be fixed as long as we understand it better. And it's not only the case that voters might give up and go home without casting a ballot in November 2020. Bad voting experiences in November 2020 can actually depress their likelihood of voting in 2022 and 2024 and subsequent election cycles. So we believe this is very important. We also know from previous research that 3.5 million voters waited longer than 1 hour to cast their ballots in 2012. And this was not randomly and evenly distributed across the population. There are certain types of voters this affected more so than others. The research shows that racial demographics are one of the strongest predictors of how long somebody waits in line to vote. And we also know that non-white voters are 7 times more likely to wait longer than an hour than white voters are, and that these racial differences can affect whether or not they ultimately cast their ballots and what happens in subsequent cycles. So this is really important research. This is important work that we need to get to know much more about, and these differences and these and long wait lines can, as I said, be addressed by elections officials who can provide more poll workers and voting machines. We already know, for example, from other research that's been done, that elections officials provide more poll workers and voting machines to heavily white precincts than they do to precincts that serve minority voters. And this affects how long those types of voters wait in line, and ultimately whether they are disenfranchised or not. So this is important research, and this research leverages technology to be able to understand this and to study this in a way that's accurate. We also know, for example, that bad voting experiences may explain some of the drop-off in minority turnout in 2016. Because problems with voting and the ease with which they voted or tried to vote in 2008 and 2012 may actually have contributed to them choosing not to vote or trying not to vote in 2016. So this is a really big problem for American democracy, and we hope that this project and the app that we're developing actually helps us to study that and understand that, and ultimately to work with elections administrators and other officials, as well as other researchers, to try to strengthen democracy by improving the voting process and making it easier and faster for people to cast ballots so that it is less onerous and less costly for them to show up and cast ballots on election day or through other means, voting early or even voting by mail. So we're really excited to feature this technology and unveil it for you today, and also to ask for your help. If there are ways in which you can help us find partners and study participants in North Carolina and Arizona, which are likely to be competitive states in 2020 by all accounts. It's going to be really important to study this in places like that. Those places are going to be incredibly important in the presidential election. And we ask you to stay tuned as we assess the results of our study and to reach out if you can be helpful at all in conducting this important research. So thanks for this opportunity to be with you and to share our project with you.
Next is our keynote presentation. Dale was our dream ask as a keynote, so we are thrilled to have you, Dale, with us today. We know this is an incredibly busy time for you. Dale is the director of the ACLU's Voting Rights Project and supervises the ACLU's voting rights litigation nationwide. Dale has active cases in more than a dozen states nationwide. His cases have included Department of Commerce versus New York, successfully challenging the inclusion of a citizenship question on the census, which he argued at the U.S. Supreme Court and which is featured in the award-winning documentary film The Fight, as well as Fish versus Kobach, successfully challenging documentation requirements for voter registration in Kansas, which noted election law scholar Richard Hassan has described as the most significant voting rights case this century. Dale has testified on election law issues before Congress and in various state legislatures around the country. He is also an adjunct clinical professor of law at NYU School of Law. Dale is a frequent commentator on voting rights issues, appearing on television programs including CNN, The Rachel Maddow Show, and All In with Chris Hayes, and has written opinion pieces for the New York Times, and is widely published on redistricting and voting rights in law reviews, including the Yale Law Journal Forum and the Harvard Civil Rights, Civil Liberties Law Review. Dale is the recipient of the 2020 Asian Law Alliance Legal Impact Award and the 2019 National Asian Pacific American Bar Association President's Award. In 2018, he was named to the New York City Charter Revision Commission. In 2017, Dale was named one of the best Asian American lawyers under 40 by the National Asian Pacific American Bar Association. Prior to joining the ACLU, Dale was assistant counsel at the NAACP Legal Defense Fund, an associate at Fried Frank Harris Shriver and Jacobson, and a judicial law clerk first to Judge Barbara Jones of the U.S. District Court for the Southern District of New York, and then to Judge Robert S. Smith of the New York Court of Appeals. He is a graduate of Yale Law School and Princeton University. Thank you, Dale, for being with us today.
Mr. Chief Justice, and may it please the court, the Secretary's decision rested on a single assertion that don't do this tomorrow.
Have you argued in front of the Supreme Court before?
No.
Nearly 2,000 children have been separated from their families.
ACLU, good morning.
Hundreds of parents have just lost their kids.
Free our children now!
My job is to make sure the horror of what's going on stays front and center.
Do you believe in punishment for abortion? There has to be some form of punishment.
You can't be serious. The government can't ban people from accessing abortion.
This is the president's declaration of open season on trans people.
Transgenderism is a mental dysfunction.
They want to erase trans people from public life.
6 states would lose a seat in Congress. It's all based on the census. Kind of difficult to imagine higher stakes.
The A stands for American. Americans come first. We don't appreciate your work.
You're a filthy organization. Obviously, most of you are pedophiles.
We are scrambling.
We've been actually working up a challenge. Simrat, you're literally pulling my computer off the desk.
You're not going to win every fight.
Just thinking of my own kids, it's just inconceivable.
People say, why don't you go work at a law firm? Why have this level of stress riding on your shoulders? If we lose this case, I don't know what Roe versus Wade means.
President Trump wins.
What happened, Maya?
3 minutes.
I can't go on right away.
We will go back into court. We will them up.
All I've ever known how to do is fight, and so we just keep fighting. That's what we do.
We are here right now.
If I'm not going to be a civil rights lawyer right now, in this moment, when? Hi, everyone. I'm Dale Ho, the director of the ACLU's Voting Rights Project. That was the trailer for the film The Fight, a documentary following myself and other colleagues at the ACLU, including 2 Northeastern alums, Chase Strangio and Bridget Amiri. The film has been available streaming for a few weeks now, but as of tonight, I guess it's available on Hulu as well if anyone's interested in it. I just want to start by saying thank you to Justice Burns for that kind introduction, Miel and everyone else at Northeastern who's helped organize this event, and all of you for joining us today. It's really a tremendous honor to be here with such a distinguished panel, which includes my colleague Rasan from the ACLU, Michael Lee from the Brennan Center. I like to think I have about one half of Michael's brain power, and Justice Anita Earls of the North Carolina Supreme Court, who is really a legend in voting rights and an inspiration to me. It's quite humbling to be giving the keynote in this company. So as I said, my name is Dale Ho. I'm the director of the ACLU's Voting Rights Project. I've spent most of the last 10 years of my career litigating cases around the country, fighting against a wave of voter suppression laws that we've seen since 2010. Most of these laws were recently enacted. They're of a more recent vintage than other kinds of barriers like poll taxes and literacy tests and felon disenfranchisement laws that are sort of infamous in American history. I also argued a case in the Supreme Court last year, successfully challenging an attempt by the Trump administration to add a citizenship question to the 2020 census, a move that would have been devastating for the voting rights and representation of communities of color around the country. And I'll say a little bit about that case later today. I want to spend a little bit of time today telling you about my experience over the last decade and how I understand the fight for voting rights that we are facing today. It's a battle that is against what I think of as the most ferocious attack on voting rights that our country has seen in a generation. And I want to share my experience with you by telling you first, a little bit about the conventional narrative that is used to describe fights about voting rights today, but then explaining why I think that message and that narrative are fundamentally incomplete. My message today, if I could sum it up in a few sentences, is that the fight for voting rights today is not just about access. It's not just about good government and having a well-functioning democracy, although it is about all of those things. But it's about more than that. It's about justice, it's about equality, and it's about racism and racial discrimination. Now, it might sound a little strange to say that the fight about voting rights is not a fight that's principally about access, particularly given what's happening today with the COVID-19 pandemic. The pandemic has upended our elections administration systems around the country. I'm sure everyone here is well aware of what we experienced during the primaries: poll worker shortages, polling place closures, problems with and barriers to voting absentee voting. It's not an exaggeration to say that the 2020 presidential election may be the most difficult election to administer in this country since the 1864 presidential election was conducted during the Civil War. So I just want to be clear that when I say that our problems with voting are not primarily ones that should be understood through the lens of access, but through the lens of justice, I do not mean to suggest that we don't have access problems. We do have access problems. And I want to tell you a little bit about, at the end of my talk, what we're facing as we head into November this year. But we have more than an access problem. We have a justice problem, and the sort of traditional narrative that's focused on access sometimes misses what I think are critical aspects of the fight for voting rights today. So with that, let me start with what I understand as kind of the conventional wisdom told sometimes in left-leaning circles by progressives, by members of the Democratic Party sometimes, and sometimes in the media. And it goes something like this. We've seen a war on voting rights over the last decade. The United States already had one of the worst turnout rates amongst Western democracies. We're not even in the top 30 when it comes to turnout out of the 36 countries that are members of the Organization for Economic Cooperation and Development. Michael Lee from the Brennan Center could tell you, the Brennan Center did a report in the run-up to the 2012 presidential election showing that during 2011 and 2012, 19 states passed 25 laws and 2 executive orders, making it harder for people either to register to vote or to cast a ballot. They've done that in the name of combating voter fraud, but we don't have a problem of fraud in this country, at least not systematic and not widespread. Professor Justin Levitt at Loyola Law School, an illustrious alum of the Brennan Center, did a comprehensive report looking specifically at the issue of in-person voter impersonation, the kind of voter fraud that voter identification requirements are designed to prevent. He found that between the 2000 to 2012 presidential elections, there were about 40 credible instances of people showing up at the polls trying to cast a ballot, pretending to be someone that they're not. 40 total instances from the 2000 to 2012 presidential elections, a period of time in which over 1 billion ballots are cast. I think you are more likely to be struck by lightning twice than to have someone try to impersonate you at the ballot, at the polls. Now, why is this happening then, if it's not really to prevent fraud? Well, the conventional narrative goes something like this. There's partisan gain to be had in suppressing the vote. The Republican Party tends to lose in high turnout elections, or tends to have a harder time. And so around the country, in many places anyway, has decided to pursue a strategy of reduced turnout. We see it not only in the laws and policies that they are pursuing, but also in tactics like negative campaigning and now online disinformation campaigns, which are intended to reduce enthusiasm in the electorate or stoke divisions amongst liberals and to just reduce participation overall. Now, if that's the way you understand the problem that we're facing today, then the prescription is to protect the voting rights for everyone. Maybe while the Voting Rights Act protected against voting discrimination, that is racial discrimination in voting, maybe today in the 21st century, we should be looking at measures that protect everyone's voting rights, a constitutional right to vote, or more robust federal statutory protections that prohibit any laws that make it harder for people to vote, whether racially discriminatory or not. And maybe we need to go beyond that and boost participation with more voter-friendly laws and policies. Policies like automatic registration, making Election Day a holiday, no excuse absentee voting, an issue that we at the ACLU have focused on a lot with the pandemic going on. Let's make it easier for people to vote so that everyone who wants to participate can do so without facing unnecessary burdens. Now that's, I think, the conventional left center kind of story that's told about voting rights today. And I want to be clear, I don't think that that story is false exactly, but I don't think it's completely accurate either, because it's missing something really important. And that error of omission, I think in turn leads to a misdiagnosis of some of the problems that we are facing as a country, and it leads to prescriptions that, while helpful, are only partial solutions to our problems. And here's what I mean by that. The omission that this conventional story tells about voting rights today is that it neglects the role that race and racism have and continue to play in the struggle for voting rights in America. Now, that struggle for voting rights, that story, it's not one of inevitable or linear progress, as sometimes we are taught in schools. Instead, it's a story of contradiction, contestation, contingency, and at times backlash. And the moment that we are experiencing today as a country is, in my view, just the latest chapter of that story that this country has been going through since the founding, and it recapitulates many of the same beats. So what do I mean by that when I'm talking about our history? Let me back up for a second. The received wisdom we're sometimes taught in schools is that the founding was a period of time in which only rich white men could vote. But over the last 200 and almost 40 years, we've seen slow and linear progress towards universal suffrage, which we have today, with the electorate slowly expanding in concentric circles to arrive at the present. Now, that's not entirely inaccurate, but it's not exactly precise. In fact, at the founding, free men of color, not women, unfortunately, but free men of color who met their state's property requirements could actually vote in some states. New Hampshire, Massachusetts, New Jersey, New York. New Jersey was interesting because women who met that state's property requirements could also vote at the founding. Another state where free men of color could vote was North Carolina. And I think that's a very, very interesting case because you have in North Carolina Black suffrage at the same time that you have chattel slavery. That's an incredible contradiction that today, even when I look back on it now, I have a hard time wrapping my brain around. But that persisted in North Carolina for decades. It wasn't just a blip. It wasn't until 1835 when North Carolina's state constitution made two changes to that. First, it relaxed the property requirement for white men, so it made it easier for white men to vote. But at the same time, the 1835 North Carolina Constitution abolished the franchise altogether for Black men, and it did so in the wake of Nat Turner's rebellion. Now, I want to emphasize that for a moment, because what I think that history, that short period of history shows, is that the right to vote is not something that has moved unidirectionally in this country. It's expanded, it's contracted, and sometimes it's done both of those things for different groups of people simultaneously. We see that happening again throughout our history, and I think that's something that's hard to understand if you approach voting rights issues from a pure democracy, participation, and access frame without adding a racial justice lens to your understanding. So another moment in history which I think recapitulates some of these beats. Reconstruction and the years after Reconstruction. Now, as we all know, the Reconstruction Amendments, the 13th, 14th, and 15th Amendments, they abolished slavery. They guaranteed equal protection to all and citizenship to everyone born on American soil. They also made sure that every person in the United States was counted in the census for purposes of apportioning representation in the United States House of Representatives and consequently in the Electoral College, something I'll return to in a minute at the end when I talk about the census. And then the 15th Amendment banned racial discrimination on the basis of, banned racial discrimination in the voting process. The effect of the Reconstruction Amendments, the change that they brought about was stunning. You know, throughout the 1880s, state legislatures in some of the states of the former Confederacy consisted of more than 40%, even close to 50% of African-American members. We're talking about less than a generation, just 15 years from the end of the Civil War. People who were property were receiving equal and proportional representation in their state houses less than 2 decades later. That bright, I think, shining moment where we had a multiracial democracy unfortunately met a very, very ferocious backlash, as we all know. Constitutions of the 1890s and 1900s in the South contained a bevy of new restrictions on voting, which in many cases were facially neutral, did not have racial discrimination inscribed into their text, but they had the purpose and successful effect of disenfranchising Black Americans. Literacy tests, poll taxes, felon disenfranchisement laws. All of these restrictions justified as supposedly necessary to preserve the purity and integrity of the ballot box, instead enforced a racial caste system in our country that would continue to persist for decades. And so the progress of Reconstruction gave way to more than a half a century of Black codes and Jim Crow. Now, the Civil Rights era brought, I think, what I would describe as a third wave of democratic expansion in this country. In 1964, just a year before the Voting Rights Act was passed, fewer than 6% of Black voters of Black people eligible who would otherwise be eligible to vote in Mississippi were registered. In Alabama, the number was less than 20%. Now, that all changed with the Selma to Montgomery March and the passage of the Voting Rights Act of 1965, when John Lewis and other heroes, captured the nation's attention on the Edmund Pettus Bridge. And from that moment, a new era in American democracy was born. Literacy tests and poll taxes fell, not just in the South, but around the country. And in that moment, right, we forged a national consensus that racial discrimination has no place in the voting process. That's not to say we didn't have problems with racial discrimination in the ensuing years and decades, but even as power shifted hands at the national level between the parties, like a pendulum, the Voting Rights Act and the consensus around it as a crown jewel of American civil rights protections did not fade. It was reauthorized in 1970 by Richard Nixon, again in 1975, again in 1982, signed into law by President Reagan, who coined that expression, referring to the Voting Rights Act as a crown jewel of American civil rights protections. And then again, most recently, by George W. Bush in 2006, after a Voting Rights Act reauthorization passed the Senate 98-0 and 390-33 in the House. Now, that's not to say that we didn't have controversies about voting rights. We had many of them from 1965 to 2010. But we had a consensus nationally amongst our leaders. That consensus, I think, sadly, has broken down over the last decade. And as I mentioned before, we saw a wave of laws making it harder for people to either register to vote or cast a ballot in the run-up to the 2012 presidential election. And that Brennan Center report identifying 19 states passing 25 laws that made it harder for people to participate. Now, I will say that I was not prepared for that moment. I was a young lawyer at the NAACP Legal Defense Fund at the time in the voting rights project there, and we were not at all ready for this. In 2011, we were kind of in the midst of the redistricting cycle. We were thinking about issues like felon disenfranchisement. How can we make progress on that? An issue that had been very, very difficult to get progress on over the last few decades. We were completely unprepared for dozens of laws making it harder for people to vote in the midst of a presidential campaign. Now, why did that happen? I think it's hard to understand what happened in the run-up to the 2012 presidential election without looking at the 2008 presidential election, the most immediate preceding one. That election was obviously notable for the ascension of Barack Obama to the presidency, the nation's first Black president. But when you look at the voting patterns, I think some very interesting trends emerge. So first is population growth of communities of color. The 2008 election was the most diverse election it had featured the most diverse electorate in our nation's history up until that point. More than 25% of the eligible electorate were voters of color. That was a first. Second thing, skyrocketing participation levels by voters of color. Turnout was up overall in 2008, but it was particularly high amongst voters of color. So if you just compare 2004 to 2008, one presidential election cycle, and compare the number of ballots cast, not the turnout percentage, but just the sheer number of ballots cast by the nation's 3 largest racial and ethnic minority groups, you see a massive surge. So 15% more ballots cast by Black voters in 2008 as compared to 2004. 20% more ballots cast by Asian Americans in 2008 as compared to 2004. And 25% more ballots cast by Hispanic Americans in 2008 compared to 2004. Some of that's population growth, but a lot of it is higher turnout levels. When you compare that number to non-Hispanic whites, number of ballots cast by them in 2008 compared to 2004, 0.5%. So we see a surge in participation by voters of color, and we see white voters shrinking concomitantly as a share of the electorate. Third piece, I think, racial polarization. Now, racial polarization is not a new feature of American life, and it wasn't new in 2008. But we saw, I think, some interesting polarization patterns in the presidential election in 2008. If you compare Barack Obama's vote share in 2008 to John Kerry's in 2004, amongst voters of color, some interesting things, right? Obama did 7 percentage points better than John Kerry did amongst Black voters. He did 6 percentage points better amongst Asian American voters. And he did 14 points better amongst Hispanics than John Kerry did. Now, he also did better amongst white voters. He did about 2 points better. And he was very effective in a number of very white states like Iowa. I think, when Obama won the Iowa caucuses, a state that's 95% white, that really captured the nation's imagination in 2008. But he also bled support amongst white voters as compared to John Kerry in many places, and even amongst white Democrats. Barack Obama was flat. While he's doing much better amongst voters of color, he was flat amongst white voters as compared to John Kerry in 6 states. And he actually did worse than Kerry did amongst white Democrats in 3 states. And that's pretty remarkable, given his sort of overall growth in the electorate, and also what the electoral environment was in 2008. Near economic collapse, 2 unpopular wars, economy plunging into the Great Recession. That he's doing worse amongst some members of his own party than the candidate 4 years ago, I think, is interesting. So what happened in the 2008 election? I think there were more people of color than ever. They were turning out at higher numbers than ever. And Obama ran up the score amongst them. When you understand those things, then what happened in the run-up to the 2012 presidential election makes a lot more sense. Because those restrictions that we saw in the 2012 presidential campaign, while facially neutral, they didn't make it harder for everyone to vote. It was almost as if by coincidence, they always, almost without fail, disproportionately affected precisely those demographics that emerged in 2008. Whether it was restrictions on voter registration drives that we litigated at the Legal Defense Fund in 2012 in Florida, a state where almost 20% of Black and Latinx voters register to vote through a registration drive as compared to about 5 or 6% of white voters. A strict identification law in Texas where people could vote with a concealed weapons permit, but not a University of Texas student ID card issued by the state of Texas. Or back in Florida again, early voting cutbacks that, among other things, eliminated voting on the last Sunday before Election Day, a time when many Black churches engage in souls to the polls efforts to assist members of their congregations get to the polls, a day on which Black voters constituted 33% of voters, despite only being 20% of the electorate overall. When you look at that range of restrictions, it's hard to understand them as anything but a backlash to the diversification of the electorate in 2008. Now, each one of those laws that I just mentioned, voter registration cutbacks in, voter registration restrictions in Florida, the elimination of Sunday voting in Florida, a voter identification law in Texas. Each of them were blocked by courts. Most of them, two of them under Section 5 of the Voting Rights Act, a provision of the act that you'll hear more about from Justice Earls, who is going to go into the history of it a bit. A provision that required states that had the worst histories of discrimination to obtain federal approval before making changes to their voting laws. And Section 5 of the VRA really saved the day in the 2012 presidential election by blocking many of these voter suppression efforts. But in 2013, the Supreme Court effectively immobilized that, what we call the pre-clearance regime of the Voting Rights Act, by striking down a key provision of the act and effectively released those areas of the country from federal supervision and turned them loose to make any changes to their voting laws that they saw fit. And the deluge began again. In 2013, we saw a new wave of voter suppression laws, and that once again, without fail, disproportionately affected voters of color. And I'm just going to talk about one of them, a law in North Carolina that passed that year, and a case that I had the privilege to litigate with Justice Earls and her team, a member of which, Allison Riggs, who's the current acting executive director of the Southern Coalition for Social Justice, which Justice Earls founded, a case that Allison led, and I had the privilege to work with her on it. So North Carolina, it was the closest state in the presidential contest in 2008. It was decided by 20,000 votes in a year that saw record levels of Black turnout. In early 2013, the North Carolina legislature began considering a strict voter identification law. Now, we weren't a fan of this law at the ACLU, I'll say, and many people in the civil rights community weren't. But as far as strict voter identification laws go, it wasn't the worst. It permitted people to vote with any form of government-issued photo ID, at least the initial draft did, and that's all it did. It passed the House in North Carolina after a full legislative process, and then it was sent over to the Senate, where nothing happened on the bill for months. Then, after the Supreme Court decided the Shelby County case and released North Carolina from federal supervision, then a prominent state senator in North Carolina said, good, now we can go forward with the full bill. Now, no one knew what that meant at the time. But then several weeks later, with just 2 days left in the legislative session, the full bill was released. Now it was no longer about a dozen pages and devoted only to photo ID. It was now several dozen pages, and it did a number of other things. So in addition to imposing a strict identification requirement, it eliminated a week of early voting. It eliminated same-day registration during the early voting period, which North Carolina had for a few election cycles. It eliminated a provision requiring the counting of ballots cast at the wrong precinct for any offices that voter was eligible to vote for. You can imagine, if you end up at the wrong precinct, maybe through no fault of your own, maybe due to state or administrative error or bad information from a poll worker, and you end up casting a ballot there, your ballot still has a number of offices, the location of your precinct, for which the location of your precinct doesn't matter. Things like governor or senator or president, maybe your congressional district. North Carolina, for a number of election cycles, counted those offices for which the voter was eligible, even if the ballot was cast in the wrong place. This bill did away with that. The bill also got rid of pre-registration for 16 and 17-year-olds. So people who go and get their driver's license at 16 or 17, they could fill out a voter registration form like a lot of people do. In fact, a plurality of people in America today register to vote at the DMV. 16 and 17-year-olds in North Carolina could do that too, and their registrations would be held, and they would automatically become registered when they became of age. And that was something to minimize the number of interactions with the state that they would have, something that over 150,000 people had used in North Carolina over a 4-year period. The bill did away with that as well. And it also, for good measure, got rid of a high school civics program to encourage registration and voting amongst high school students. Okay, so we knew this was a monstrous voter suppression bill. But here's what the litigation revealed. The litigation revealed that while this bill was pending in the Senate and there was no action happening on the surface, no public hearings, no comment, no public amendments to it, there was in fact a lot of activity happening. There were emails between legislative staff and the North Carolina Board of Elections requesting racial breakdowns of early voting usage and of same-day registration usage. And when that data revealed that 70% of Black voters voted early in person in North Carolina in the 2012 and 2008 presidential elections, as compared to about 50% of white voters, only then did a week of early voting get cut and for that to be added to the bill. Only when that data revealed that Black voters, who were about 22% of the electorate, were over 30% of the voters who relied on and used same-day registration, was a provision added to the bill to eliminate same-day registration. There were also emails between legislative staff and the North Carolina DMV asking for a racial breakdown of who has driver's licenses, and emails between legislative staff and the UNC system asking for a racial breakdown of who holds University of North Carolina student ID cards. And after that, only after that, does the ID provision of the bill change from a bill that would permit people to vote using any form of government-issued photo ID to a bill that would only permit people to vote using certain forms of government-issued student ID. So when the data came back, North Carolina continued to permit people to vote using driver's licenses, but took out certain forms of ID. Student ID cards issued by the state would no longer be acceptable for voting purposes. Municipal employee ID cards, no longer acceptable for voting purposes. And public assistance ID cards, also no longer acceptable for voting purposes. The only form of voting that data was returned on, which the data showed was disproportionately used by white voters, was mail-in absentee voting in North Carolina. And the final version of the bill exempted absentee voting from the ID requirement. We and at the ACLU, along with the Southern Coalition for Social Justice, which I mentioned, really led this case, litigated this for a number of years, and in 2016 received a unanimous ruling from the Court of Appeals for the Fourth Circuit, finding that the North Carolina legislature had acted with, quote, surgical precision in targeting African-American voters. And that was a remarkable moment, I should say. For years, civil rights advocates like myself had been advised over and over again not to be careful about making claims about racially discriminatory intent. But the facts in this case, I think, were just overwhelming and led to, I think, a very remarkable finding by a court of appeals that a state's legislature acted with that kind of discriminatory animus. So when I think about a case like that and the other cases that we litigated during this period, what it tells to me is that a lens that focuses exclusively or perhaps even primarily on partisanship to the exclusion of race makes two fundamental errors. It makes a diagnostic one because it presupposes that there's a kind of race-blind but partisan political contestation that's happening right now, which in fact has never, in my view, existed in America. And it assumes that racial discrimination is really nothing more than irrational prejudice, rather than a system of power. It makes an assumption that Jim Crow and mass disenfranchisement before the civil rights era were solely about inflicting dignitary harms on Black people and other people of color. And that was, in fact, one of the goals of those systems. But those systems were also there to preserve power, to preserve a political system of white supremacy. And while today's voting rights disputes are, of course, very different from the ones that we saw post-Reconstruction and in the run-up to the Voting Rights Act and during the Civil Rights era, they're different in very, very many ways. But they, too, are not just about partisanship. Race is a fundamental component of the voting rights disputes that we are seeing today and continue to fight in 2020. So where are we today in 2020? Well, I divided in my head between pre-pandemic and I was about to say post-pandemic, but I don't think we're there yet. So I'll tell you a little bit about pre-pandemic times and then pandemic times. Some of the ongoing fights on voting rights that we were having running up until the start of 2020 and are still fighting today. I want to mention two. The first is in Florida, where we're fighting a battle over people's right to vote after they have finished their sentences for criminal convictions. There are approximately 6 million Americans today who cannot vote due to a criminal conviction. Over a quarter of them live in one state. They live in Florida, which is one of 4 states in which the Constitution requires the disenfranchisement of people for life for commission of a single felony offense. In Florida, with a caveat, because that changed in 2018 in Florida, which I'll explain in a moment. In Florida, before that constitutional amendment in 2018, 1 out of 10 adult citizens were banned from voting for life. 10% of the state's adult citizen population. And I tell people those numbers, sometimes they look at me like I'm crazy, like they can't believe it, but that's the number. For Black Floridians, the number, the percentage was even higher, more than twice as high. Almost 25% of Black Floridians banned from voting for life because of a single felony conviction. When you think about those numbers, it's really kind of hard to describe Florida as a functioning democracy, but I guess after 2000, maybe Florida isn't really thought of one anyway. In 2018, Florida voters went to the polls and changed all of that. In November that year, voters approved a constitutional amendment that would automatically restore voting rights to people upon completion of their sentences for felony convictions. It was potentially the largest expansion of voting rights since 18-year-olds won the right to vote. In 2019, the Florida legislature responded to that with a law that provided that a person's felony sentence is not complete until that person repays all legal financial obligations associated with their sentences. That is all fines, all restitution, all court fees and costs. We did an initial analysis. We sued the day the governor signed that law, that bill into law, and conducted an analysis. And we found that of the people for whom records we could find, which was over 1 million Floridians who were off paper, they had finished parole, probation, incarceration, obviously. For 1 million of those people, we could locate some records, and 80% of them still owed some legal financial obligations. In most cases, they were not fines or restitution. They were, in fact, just court costs. So financial costs assessed to them simply for going through the system. And Florida slaps on about 6 different kinds of costs. It even assesses you a cost to determine whether or not, if you're a criminal defendant, you are sufficiently indigent as to be entitled to a public defender. We took that case to trial earlier this year and won a resounding ruling from the trial judge there, striking down the law and ruling that while it's permissible for Florida to require these payments, it can't draw blood from a stone. It can't demand that people who can't afford these payments repay them before they become eligible to vote again, because that would effectively reinstitute lifetime disenfranchisement. The most remarkable thing I would say about that case is what we learned in discovery was not just that many people owed a lot of money, not just that there were racial disparities in that, but that many people could not even determine how much they owed. That the state's record-keeping system was so bad because it was not centralized in the state, but rather decentralized at the county level. And because the counties didn't do a good job of keeping track of how much money people paid, and because the county's records only went back so far, and we had clients with convictions from the 1990s or even earlier, many people who were off paper, had finished their sentences, wanted to register to vote, couldn't even figure out if they still owed any money associated with their sentences, or if they did, couldn't figure out precisely how much they owed. And yet, when presented with a voter registration form, they were required to swear under oath, under penalty of perjury, that they were in fact eligible to vote in Florida. They were caught in this Kafkaesque system, which the trial court recognized was unconstitutional. But unfortunately, just a week and a half ago, we received a ruling from the 11th Circuit. It was 6-4. So the full court heard the case of 10 judges. And if we had just gotten one more vote, we would have had a different outcome. But the court ruled 6-4 to reverse that ruling and found there was no constitutional problem with Florida's system. Florida did not have a law on criminal disenfranchisement until after the Civil War. And I think that's interesting and remarkable because it tells you that this law that we're fighting against, it's not some sort of pillar of government in Florida that has existed since Florida became a state, or something that dates back to, ancient Greco-Roman Republican practices. It's actually a law of relatively recent vintage, and one that traces its roots to one of the darkest moments in our country's history. A second case that I want to mention, and hopefully one that can leave us on a bit of a higher note, a case that I argued in the Supreme Court last year, challenging the Trump administration's attempt to add a citizenship question to the census. Now, I don't want to spend too much of my time on that today. I want to make sure that we have enough time for some questions and answers. But this was a question that had not been on the census in 70 years. And it hadn't because the professionals at the Census Bureau understood that it deterred census participation. According to the Census Bureau's own estimates, it would deter about 9 million people from participating in the census. That's as many people as are in the nation's 11th largest state, New Jersey. If you put those 9 million people together, they would have 12 representatives in the House and 14 votes in the Electoral College. Why does that matter for those people not to be counted in the census? Because the census count is the count that's used to divvy up representation in the House of Representatives and to allocate electoral votes to the states. And because of that, states with larger immigrant populations, which would see a chilling effect in census participation as a result of this question, would have lost out. Our analysis was that there were 6 states at risk of losing 1 or more seats in the House, including California, Arizona, Florida, New York, Illinois, and Texas. And even within states, communities with larger immigrant populations would have gotten less representation, fewer districts, and would have seen power flowing out to more rural and disproportionately white areas of those states. Now, against all odds and some very wise Supreme Court watchers, we won the case. There is no citizenship question on the census this year. But now the administration has taken it to another level. Last July, they announced that they would just exclude the 11 million estimated undocumented immigrants in this country from the census count used to apportion the House altogether. We're talking about a group of people who have lived in the United States a median of 15 years, all based on the notion that they're not really in the United States because of their lack of lawful status. It's an unprecedented act. No census in our history has ever discounted people or not refused to count people because of their immigration or citizenship status. It's a breathtaking, it's breathtaking in its blatant defiance of the Constitution. I'm happy to report that a week ago, we won a ruling from a federal court in Manhattan blocking this effort. This morning, the administration filed its notice of appeal to the Supreme Court, so the fight goes on. What I hope, though, and I know I need to wrap up, what I hope that this conversation or this discussion has revealed is that our fights about voting rights are not just about access. This election season, we definitely have access issues, and I would love to talk more about them. But as we get past the pandemic and longer term, I think it's important to remember that easier access to voting will not solve all of the voting-related problems that we currently face. Automatic registration won't eliminate the relic of Jim Crow that we're fighting in Florida. Making voting easier won't solve the persistent and repeated efforts to dilute the voting power of immigrant communities and other communities of color that we see instantiated in the census fight. Making voting easier isn't going to solve the problem that isn't going to solve the fact that by 2040, when this country will officially be a majority minority country, 70% of the country is projected to reside in only 15 states, which would mean that only 30% of the country would wield 70% of the power in the Senate and would have outsized power in the Electoral College. I think it's critical to see the connections between restrictions on voting and the ability to participate in communities among voters of color. And it's impossible to see those connections if we don't acknowledge the role that race has played and continues to play in the struggle for voting rights in this country. Thank you.
Dale, that was really wonderful. Thank you so very much. I thought I knew a fair amount about voting rights, but I certainly have learned a lot today, this afternoon, and I hope our participants and our visitors, attendees have also done that. What's I think wonderful about your presentation is that it sets the grand context and also the ongoing battles. But right at the moment, I think what people are really worried about is both the security of the elections and the not, well, maybe the true validity, but the perceived validity of the vote count. And so I think every state has different rules about how it counts its votes, who can vote and how they vote. Whether they start counting the absentee ballots before the polls close, or they have to wait until the polls close and start them. So that I think there's a general concern about this vote counting. And I'm wondering if you can talk a bit about that and whether this is both a legal issue or a really more of and I say small p political, which is a communications issue, to really assure that all the votes get counted and people trust the election. I know it's a big question, but maybe you could give us some comments on that.
Well, I'd say that it's both. We have both a legal issue and we have a political one. The legal issue is that when COVID hit and people were, I think, very rightfully concerned about having to choose between their health and exercising their fundamental right to vote, we had a legal regime that was not prepared to accommodate that. 33, and then shortly after the pandemic began, 34 states permitted everyone to vote by mail. That's great. That's a majority of the states that represent a majority of the country. But that still left 16 states where people couldn't, if they wanted to, just vote by mail, right? To avoid the crowds that we saw, say, in Milwaukee during the primary, when Milwaukee went from 180 to 5 polling locations, and we saw these multi-hour waits, and dozens of cases of COVID ultimately that were traced to that election, and the lack of preparation. I mean, this was right as the pandemic was beginning, right? So the good news is, I think, is that of the 16 states that weren't permitting everyone to vote by mail when the pandemic began, 11 of them have modified their rules for at least this year so that anyone can vote by mail. But we had to sue Tennessee, for example, where even people with severe comorbidities, our client was a 2-time cancer survivor, but Tennessee took the position that because he could physically travel to the polls, he was not ill or disabled to the extent that he was entitled to vote absentee under the statute. Well, that's changed. Tennessee will now let people at high risk of severe complications from COVID vote by mail, but a lot of people still can't. So we have a legal problem. Those legal issues continue to be litigated today. There's going to continue to be some controversy around those over the next few weeks. But then we're going to know the rules of the game, I think, pretty well. And then we're going to have political challenges. Because of the number of people who are voting absentee, because of the time that it takes to count absentee ballots, and because some states, including the 3 that were pivotal in the 2016 election, Wisconsin, Pennsylvania, Michigan, do not permit the processing of absentee ballots until election day or even election night in the case of Pennsylvania and Wisconsin. You have to wait till the polls close before you can even start verifying the information on absentee ballots to ensure that those are valid ballots, let alone taking them out, unfolding them, loading them into the machines, which all takes more time than counting in-person votes. It's conceivable that we're not going to know the winner of those states on election night. And the president has, to his discredit, gone around the country casting doubt on the legitimacy of ballots cast by mail, despite the fact that he votes by mail. And you could see a situation where we have a huge chunk of the ballots out on election night, yet to be processed and counted in pivotal states. There's a big partisan skew in terms of who's requesting absentee ballots right now. It's almost 2-to-1 Democrat to Republican, which I think reflects the partisanization of concerns about the virus. So you could see an in-person electoral vote, an in-person electorate in some of these pivotal states that is predominantly Republican, and an absentee vote, which is predominantly Democratic, but we only have the in-person vote counted in some of these states on election night. The president appears to be ahead. He declares victory. He says all of the absentees are fraudulent and illegitimate, which he's been kind of laying the groundwork for. And then we have confusion. We have an environment fit for chaos, and we have a political problem because there's no way to sort of litigate against a president who's undermining confidence in the electoral system. Now, if someone tries to stop the ballot counting or something like that, then we have a legal problem and we'll have tools at our disposal. But I think it's very, very, very important that people understand that this election could be different. We may not get that instant gratification that we as Americans have grown accustomed to, where the polls close and 5 minutes later, the networks are calling a state for one candidate or the other. It might take more time this year, but that's not a sign that something went wrong. It's more important to get the vote count right than to get it fast.
Well, thank you very much. I think what you've highlighted is what everybody actually is really worried about. But I think that the ACLU has done an amazing job in protecting the vote legally. I think it is for other groups to do the communications about this and really educate voters about how it can take a while to count these votes. And it doesn't mean they're illegitimate. It doesn't mean they haven't been cared for. But I think we'll rely on you, at the ACLU, to protect the legal part of this, and we'll hope some other people step up to do the communications. Dale, that was really great. Thank you so very much. It was great. And we're so glad you were here. Thank you. We're now going to our panel. And I'm very pleased to introduce our moderator, Alan Solomon, who will then introduce the panelists. But I want to say that we have put together some amazingly knowledgeable people who have knowledge about voting rights and the battle for voting rights across a wide range of areas. Alan is a longtime friend and a social activist of great note. He's the former ambassador to Spain and Andorra, and he serves as the Pierre and Pamela Omidyar Dean of Jonathan Tisch College of Civic Life at Tufts. Before his posting to Madrid, Alan chaired the bipartisan board of directors of the Corporation for National and Community Service. This is a federal agency that oversees such domestic service programs like AmeriCorps, Learn and Serve America, VISTA, and Senior Corps. He was first appointed to the board by President Clinton in 2000, reappointed by President George W. Bush in 2007, and elected chair in 2009. Throughout his career, Alan has embraced the ability of political activism and public service to benefit society. I've long admired his social activism, and I thank him very much for being with us today and moderating this exceptional panel. So over to you, Alan.
Thank you very much, Nani, for the kind words, and congratulations on your remarkable career of civic leadership, and for supporting the Public Interest Law Scholars Program here at your alma mater. Thanks also for conceiving and chairing this important conference, and thank you for inviting me to participate. We are gathered here virtually during a critical period in the 2020 election season. I think we would all agree that this is one, if not the most pivotal election in our lifetimes. And we're here to discuss one of the most central challenges to our nation: preserving, protecting, and hopefully expanding voting rights. Dale Ho just described this period as one in which we've seen the most ferocious attack on voting rights in a generation. Dale also reminded us that we can't talk about voting rights without recognizing the centrality of race and racism in this discussion. Race is embedded in every topic we will cover today, and we can't and won't be antiseptic in our conversations. Let's keep in the forefront of our minds that when we debate these issues or discuss them, we're really talking about the fundamental rights of all individuals to be full participants in our shared democracy, the rights of our neighbors, our family members, our colleagues, our friends, and our fellow citizens. I was privileged to have known the late Congressman and American hero, John Lewis. And as we begin this conversation, allow me to invoke his words. The vote is precious. It is almost sacred. It is the most powerful, nonviolent tool we have in a democracy. I know that each member of our panel agrees, and we are very fortunate to have this team of voting rights experts with us today. So I'm going to be brief in my introduction so we can dive into their expertise and share it with our audience. Professor Moon Duchin is my colleague at Tufts. She is a senior fellow at Tufts University's Tisch College of Civic Life and also an associate professor of mathematics. She also serves as director of the Interdisciplinary Science, Technology, and Society program. Her mathematical research is in geometric group theory, low dimensional topology, and dynamics. And if she'd like, she could explain to us what that means. But more importantly, for the purposes of today's discussion, she's also the leader of the Metric Geometry and Gerrymandering Group, a Tisch College-supported project that uses advanced mathematics to focus on the issues of electoral redistricting and racial and partisan gerrymandering. Associate Justice Anita Earl sits on the Supreme Court of North Carolina. She founded and is the past executive director of the Southern Coalition for Social Justice. Previously, Justice Earl served as Deputy Assistant Attorney General for Civil Rights at the U.S. Department of Justice in the Clinton administration. And I didn't get a chance to ask her if she worked with and knows our former governor, Deval Patrick, but I gather that would be the case. She also served on the Equal Access to Justice Commission and the North Carolina Board of Elections. She has worked extensively on voting rights issues, as we heard earlier. And while at the Southern Coalition for Social Justice, Earl's represented clients in several notable voting rights lawsuits. And she served as lead plaintiff's attorney in North Carolina v. Covington, that landmark case that ultimately rose to the U.S. Supreme Court and which in 2017 affirmed that 28 of North Carolina's State House and Senate districts were unconstitutional racial gerrymanders. She has taught at Duke University, the University of North Carolina at Chapel Hill, and the University of Maryland. She graduated from Williams College and received her law degree from Yale Law School. Rahsaan Hall, who's a proud graduate in the class of 1998 from Northeastern Law School, is the director of the Racial Justice Program from the American Civil Liberties Union of Massachusetts. In this role, Rahsaan helps develop an integrated advocacy approach to address racial justice issues. Through legislative advocacy, litigation, and community engagement, the program works on issues that deeply impact communities of color and historically disenfranchised communities. Prior to joining the ACLU, Rahsaan was the deputy director of the Lawyers Committee for Civil Rights and Economic Justice, where his work included policy and legislative advocacy, community outreach, and maintaining a litigation caseload dealing with voting rights, police misconduct, and public accommodations. Rahsaan also headed up the Voting Rights Project that included coordination of statewide election protection initiatives and voting rights litigation. And he was also involved with community coalitions on redistricting after the last census in 2010. And last but certainly not least, Michael Lee is at the Brennan Center for Justice, where he serves as senior counsel for democracy. He joined prior to joining the Brennan Center, Lee practiced law at Baker Botts in Dallas for 10 years. He was the author of a widely cited blog on redistricting and election law that the New York Times called indispensable. His specialty is working on redistricting, voting rights, and elections. He's a regular writer and commentator on election law issues, having appeared on the PBS NewsHour, MSNBC, and NPR, and in print in the New York Times, the Los Angeles Times, US Today, among others. And now if we were live, everyone would applaud for the quality of the panel that we've brought together. So I hope you'll all just imagine a virtual applause, because we're really privileged to have such a stellar group of panelists. As you can tell, they come from a broad range of backgrounds and expertise. So I'd like to start by asking each of the panelists to briefly tell us how you got involved in voting rights work and what motivates you to keep going. And let's reverse the order of the introductions and start with Michael Lee.
Well, I guess the easy answer to that is I grew up in Texas, and I think it's hard growing up in Texas not to be aware of the enormous disparities and the discrimination that goes on in the voting context and the battles that the Latinos and Black communities have had to actually realize power. That's been true whether it's Democrats in power or Republicans in power. And I think my interest really first got peaked in the early 2000s when Texas went through this wild round of mid-decade redistricting, where at one point the legislature fled to New Mexico, and another point they fled to Oklahoma. And it really just seemed totally crazy. And I was in private practice doing some election law as part of that, but started writing a lot about redistricting. And then one thing sort of led to another, and it sort of it draws you in, and 10 plus years later, here I am. So that's a short answer.
Thank you. Rasan?
When I was growing up, my parents made sure I saw the eyes, and watching that as a young boy, it instilled within me the notion that voting is an essential component of full citizenship in this country. And looking at the sacrifices that people made, the great risks that they took to participate in the franchise or exercise the franchise was something that was not lost on me. And so when I was in law school at Northeastern, I felt a little disappointed because I thought to myself, the civil rights movement has passed, and there aren't these type of significant civil rights issues. And I graduated in '98, but that was just a function of me not being fully aware of all of the injustices that continued to happen. And so, when I went to work for the Lawyers Committee for Civil Rights in Boston, that was my first opportunity to be engaged in voting rights work. And it just tapped into those earlier images and memories from what I saw through that documentary, and an understanding of the sacrifices that people had made, particularly Black people, to ensure the franchise for everyone in this country.
I think it's worth pointing out that we have one person from the blue state of Massachusetts, one person from the red state of Texas, maybe a little purple now, but in any event, both of whom have been drawn to the same struggle. Thank you. Justice Earls?
Yes, thank you so much. I'm just thrilled to have this opportunity to be on such an amazing panel. I grew up in a mixed race family. My father's Black and my mother's white. And that certainly gave me an appreciation of how the law can impact our lives. It was illegal for my parents to marry. And, it took some civil rights lawyers to change that. So I always knew I wanted to be a civil rights attorney. I think I got most involved in voting rights because I came out of law school in 1988, and that was 2 years after Thornburg versus Jingles. And I went to the law firm in Charlotte that had litigated that case, Julius Chambers law firm, the attorney who had argued that case in the Supreme Court. And it was the golden age of being a voting rights attorney, because that was the moment at which vote dilution cases on behalf of Black voters were exploding, if you will, across the South. It's been called by some observers the quiet revolution in the South. And so I got to file lawsuits and settle them immediately because liability was so clear. And that really, I think, was just enormously rewarding to see how communities became empowered in that time. So.
Well, let's hope that the three attorneys on the panel and the attorneys in the audience can create the next golden age of voting rights, because as we will talk about, we certainly need that. But and Professor Duchin.
Thanks, Alan.
May I call you Moon?
You may indeed. Right. So you talked about the wide range of backgrounds, but I might be a little different from some of the rest of the folks we've heard from. So I'm a mathematician, and my background is as a very, very theoretical, pure mathematician. My dissertation is on random walks in 18-dimensional donut space. Nothing to do with all of this. And I always thought that my interest in civil rights and in activism would be very far professionally from the mainstream of my work. And then in 2016, I started teaching social choice theory. And, I wanted to enliven that for my class. So that's basically the math of how voting systems work. And so I called up one of my closest, oldest friends, who is a civil rights attorney. Many of you will know, Kristen Clarke. She's the executive director of the Lawyers Committee's national office. We've been hearing a lot about the Lawyers Committee's work. And I said, hey, Kristen, why don't you come visit me and talk to my class? So she came to town, came to speak to my class, who had no idea what a remarkable opportunity that was. They were sort of texting all through her presentation. But what she said then in 2016 was that there was a big need for a new generation of expert witnesses for the kind of civil rights work that she was doing, for the kind of cases that she was bringing, that a big influx from an earlier generation was starting to look to retirement, and that with the new census in 2020, there'd be a need for a cohort of experts, and maybe different kinds of experts, maybe experts who looked a little bit different and came from somewhat different methodological backgrounds. And even if my class didn't pick up on that, I found that incredibly inspiring and a call to action. So thinking about the mathematics of voting together with this idea that there might be a need for new kinds of expertise, new kinds of faces, really brought me into this. And now it's my full-time research program. So I hope to tell you a little bit more about that as we go, but that's a little bit about the history.
Well, if I can brag on Moon for a moment, if you look at the dissenting opinion of Justice Kagan in the Supreme Court, the case involving North Carolina and Maryland, I believe, she talks about the mathematics. And I believe it was the first time in history that a amicus brief had been filed in the Supreme Court by a group of mathematicians. Moon played a central role in that. So thank you. I think we got a breathtaking history of voting rights from Dale Ho, but I want to kind of return to the Voting Rights Act and to turn to you, Justice Earls. If you can start us off in this topic by addressing the history yourself of the Voting Rights Act, but also placing it into the context of how it matters today in 2020. And then I'm also going to ask Moon and Rasan if they'd like to add anything, but let's start with you.
Well, thank you. I agree that Dale has done an amazing job of giving us the history and background of the Voting Rights Act. And so I would like to drill down on a central thesis that Section 5 of the Voting Rights Act, the preclearance requirement, the concept that certain jurisdictions could not put in place any change affecting voting unless they could prove, the burden of proof was on the jurisdiction, unless they could prove that it had neither the purpose nor the effect of discriminating against voters, that notion that jurisdictions had to do that racial impact study and proof before they could put in place a change affecting voting, that is in fact a very powerful method of showing, protecting racial equity beyond the voting context, and that's although we no longer have Section 5, that's a very powerful way, historically proved to be a very powerful way to stop discriminatory changes from being put into effect. And so let me illustrate that. And why did Congress do that in 1965? Well, it's important to remember that the 65 Act was not the first Voting Rights Act. In 1957, there had been a watered-down Voting Rights Act that it created the Civil Rights Division. In 1960, Congress gave that division the authority to litigate on behalf of voters. In the 7 years following the 1957 Voting Rights Act, 71 voting rights cases were filed across the country. The problem was that they would file a lawsuit, the jurisdiction would change something about what they were doing, not change the ultimate impact, but change something and continue discriminating, basically. And so it was this frustration, and people came and testified to Congress about how we've been filing these lawsuits and we win, we show it's discrimination, and then they just change a little bit and we still have a discriminatory system. It was Congress hearing that kind of repeated pattern of violations was continuing, that led to the understanding that this kind of mechanism needed to be put in place. So how did it operate over time? It's actually true that a lot of jurisdictions didn't comply early on. When I was at the Justice Department in the year 98 to 2000, they were still in the voting section, working with some jurisdictions that had never submitted changes to the Justice Department. But when they did comply, if you look at the number of objections, the number of voting changes affecting voting, whether it's moving polling places, changing registration requirements, drawing districts, anything you can imagine affecting voting, there were literally hundreds of objections, and they couldn't have all been lawsuits. But let me show you the impact I think it had in North Carolina. Dale talked a lot about this, but I want to just give you a glimpse of what he was talking about. So in 2011, if I can have the first slide, I show you the voting ID bill that was first passed by the North Carolina General Assembly. And it was vetoed by the governor, but it was passed when Section 5 was still in effect. So it had to comply with Section 5. And the Justice Department over the years had received numerous voter ID proposals. And one of the general rules was that we wouldn't pre-clear something unless it was possible for voters who didn't have an ID to sign their name and vote anyway. But the 2011 bill was vetoed, and when it was vetoed by the governor, she said that it would disenfranchise voters. She said the legislature should pass a less extreme bill that allows for other forms of identification. The next slide shows you what they actually did. So that bill where the legislators said, oh, now we can go with the full bill, that bill eliminated all of the forms of ID that were disproportionately shown to be held by African Americans. It kept all of the forms of ID disproportionately held by white voters. And that was no accident, as Dale explained. Next slide, one of those emails where the legislative staff is asking UNC to get them the racial data within 2 hours. So the point of those is just that when we had Section 5, it had a very strong deterrent effect. It required jurisdictions to look at the racial impact of what they were doing, and it kept from being put in place discriminatory measures. Once it was lost through the Shelby County decision in 2013, it required literally years of litigation to ultimately get a decision where a court upheld a finding that it was intentionally racially discriminatory to put that law in place. So I would submit that the relevance of the Voting Rights Act for today, let's not forget that Section 2, which covers the entire country, is permanent and still in effect. But Section 5 is a model for how, if we want to vigorously and robustly protect the right to vote, we know how to do it.
Rasan and Moon, you want to add anything about the relevance today of the VRA?
Sure. I think I just have to say how disheartening it is that Congressman Lewis could not see the passage of a new Voting Rights Act. And I think every one of us should be committed to pushing Congress to enact a new Voting Rights Act or amend the existing one so that the sacrifices that he and many others made on that Bloody Sunday were not in vain. I think it's important to understand why the voting rights was continually reauthorized for longer periods of time. I think the last reauthorization in 2006, Congress heard evidence over a period of 10 hearings and over 12,000 pages of documents and 46 expert witnesses and people who recounted in Kilmichael, Mississippi's abrupt 2001 decision to cancel an election when an unprecedented number of African Americans ran for office, or the story of Webster, Georgia in 1998, their proposal to reduce the Black population in 3 of the Education Board's 5 single-member districts after the school district elected a majority Black school board for the first time, or in Mississippi in '95, the attempt to evade pre-clearance and revive a dual registration system that was initially enacted in 1892 to disenfranchise Black voters, or in 2004 in Waller County, Texas, there was an attempt to reduce early voting at polling places near a historically Black university, and its threats to prosecute students for illegal voting after 2 Black students at that university announced that they were going to run for office. Or and again, Mississippi state legislators opposed an early 1990s redistricting plan that would have increased the number of Black majority districts, referring to the plan publicly as the Black plan, but then privately referring to it as the N-word plan, but they weren't saying N-word. That was just, a sampling of some of the testimony that both Republicans and Democrats heard and voted overwhelmingly in favor to reauthorize this act for an additional 25 years. And here we sit in the aftermath of the Shelby decision, and Justice Earl is right. We still have Section 2, but the amount of work and litigation or work in preparation for litigation to address violations of the Voting Rights Act for so many Voting Rights Act violations is just something that overwhelms the private bar. And, depending on who's in charge of the Department of Justice, how many Section 2 claims are we going to see out of that administration? And so it's important to really understand, and I appreciate Dale's recitation and Justice Earl's recitation of the history of this act and why it is so important, and that because racism and white supremacy are so much a part of the structure of this nation, that these types of efforts at disenfranchisement and suppression of votes are not just going to go away on their own, and that we need to continue to be vigilant to fight against that. And lastly, I'll just say, a study that was done in 2013 in the aftermath of the 2012 elections, where there were a rise in voter suppression laws in 2011, it showed that there was a correlation between states that had significant increase in Black voter turnout and also the turnout of poor people, and had Republican-controlled legislatures and governors saw the highest rates of voter suppression laws, whether it's ID laws or changes to the purge or reduction of hours or of days for early voting. And so it's not just by coincidence. It's where Black people are exercising the franchise, and this notion of the Browning of America cuts to the core of what people are fighting about. And this notion of making America great again, it's making it great for a small segment of society at the expense of a vast array of people who, in fact, make America what it is.
And Moon, did you want to add something?
I'll be brief because I know we have so many great topics we want to cover. But I've been thinking and working a lot on kind of the sort of 2020 outlook on the VRA lately. For those of you who've been following some of the legal developments in redistricting, you know that computing has been kind of brought to bear, especially in partisan gerrymandering, where people have tried to understand something about the baseline of what things would look like if you didn't gerrymander, by using computation to get at that, with some success. We'll talk a little bit more about that later, I'm sure. But there's now a lot of noise around bringing some of these ideas toward the VRA in some ways that might alarm some of us as folks, as folks who have a civil rights outlook. Particularly, one of the ideas in the ether right now is that computers can show you a race-blind baseline. And maybe especially with the current Supreme Court makeup, that starts to look more and more attractive. If a computer can tell you how things would look if you didn't pay any attention to race, maybe that becomes the new baseline. And I think for all of us who are critical about race, we probably think that there's no real way to be race blind. And that goes for computers as well, of course. And so just to say that I think one of the areas that's going to be really important in the coming few years is to think about the ways that computers see and don't see race. And to sort of understand all the ways that race serves as a proxy for so many other aspects of voting behavior, including, of course, but not limited to, party. So that'll be one of the things that I'll be working on in the next few years, is kind of reimagining the VRA in the kind of big data era, and thinking about the ways that it can, can't, should, and shouldn't give us a kind of race-blind baseline.
Thanks, Moon. Thank you. This next question is for the entire panel, and that is, when you think about the 2020 elections, what concerns you most about the actions that are being taken now to suppress voting? And so, in the interest of time, I'll ask each of you to take one example only, if you would, one concern that you have, and among, sadly, so many that we could choose from. And let me again turn to Michael to start.
Well, I guess for me, I am concerned about the attempts to delegitimize the election even before it happens, to sort of raise doubts about the election, because I think that that may play out really terribly post-election. If people don't accept that the result of the democratic process is a certain outcome, and if certain people try to encourage resistance to that, I worry that people are beginning to put the kindling in place to have a really bad fire afterwards, and that concerns me a lot, because this is a place that we haven't been before, right? This is something, if you go to other countries where you expect that, but this is not what happens in America. We have elections and there's a winner, and sometimes there's a bit of legal wrangling around that, 2000, for example, but people accept the democratic process for what it is. But I worry that that a lot is already being said and done, including by officials at very high levels of our government, to not accept the results of an election.
At very high levels of our government. Justice Earls, what keeps you up at night in terms of the many problems we're facing with voter suppression?
Well, I think one concern that maybe the big overarching concern I have, in addition to what Michael said, and the others, is the phenomenon that simply threatening vote suppression discourages some people from voting. And so, whether or not all the tactics that can happen around registrations and on election day, whether or not any of those actually happen, the fact that there's a lot of threats that will happen, I fear will discourage people from trying to vote. And obviously, I think that our democracy is strongest when everyone votes.
And that sows distrust and misinformation. It brings to mind some research that my colleagues at Tisch College have done, that in some states that do not have strict ID laws or difficult ID laws for students, for example, for college students, in some states without those laws, students still believe that they are subject to strict ID laws because of all the publicity that's taken place, about the difficulties in, say, states like Wisconsin. So, Rasan?
I think both Michael and Justice Earls lifted up things that I was concerned about too. So then I'll pivot to another, which is a concern around the closure of polling locations, particularly when we're in the midst of a global pandemic. The lack of poll workers may lead to the need for closure, quote unquote need for closure of polling locations, and where those locations are, and the lack of resources available for those polling locations. I know here in Massachusetts, we passed an emergency law that would allow for increased voting by mail and exemption for absentee voting by mail, but it also created a provision for local municipalities to close or consolidate polling locations. And we attempted to try to put an amendment in to prohibit those closings or consolidations if they would have had a disparate impact on groups based on race or socioeconomic status or age, but that didn't get in. And the only thing that they're required to do is to do a disparity analysis study and take a municipal vote on the closure and consolidation of polling locations. And so when we look at what happened in Wisconsin and Georgia, because of the lack of resources and polling places, that becomes a significant concern, especially when you think about communities that have the higher rates of COVID infection and higher COVID death rates as well.
I'm sure we were all horrified to read that the University of Georgia, I believe, was removing a polling location from the campus because of long lines. And I would say that I'm glad you raised the issue of poll workers, since there's an effort to recruit young people to become poll workers, to sort of replace the older people who have been that traditionally. And in some states, if not many states, you don't have to be old enough to vote in order to be a poll worker. And so we've actually, encouraged, and I invite everyone, and I don't know what the law is in Massachusetts, someone might enlighten us, but to encourage young people, even young people who can't yet vote, to become poll workers. But Moon, what's the thing that worries you the most?
Well, true to form, I'll bring up two different threats to data that are going to rise to the level potentially of distorting or diluting the vote. One is threats to voter registration databases that may be kind of below the radar for a lot of people, but it's fundamentally important. Your presence in that database and the sort of your legitimation in that database is what gives you the right to cast a ballot. And otherwise, you can be shunted into the provisional balloting system, which undermines confidence in the system for a lot of voters. It's a threat on many levels that maybe we'll talk more about later. And a second one, even though it doesn't sound directly implicated, is the threats to the census. So my co-panelists have talked about ways that raising certain kinds of questions can have a chilling effect. And so even the discussion, all the discussion of putting the citizenship question on the census raised a lot of concerns about getting people to respond. And your census response goes directly into the apportionment formula that decides how much representation the states have in the House of Representatives, but also within state apportionment relies on the census. So that's a second data threat that will kind of work its way toward something very visible when it comes to the right to vote.
Thank you. I'm hoping we're going to get to talk a little bit about election technology and outside interference, but we have two of the nation's experts on gerrymandering and redistricting, and it's hard to talk about voting rights and voting suppression without considering the role of gerrymandering, both partisan and racial. And so with two leading experts in that area who approach this from different angles, I'm going to ask Michael and Moon, if you tell us what's the current state of play with regard to gerrymandering and what cures are available. And I think we're going to start with Moon, if I'm not mistaken.
Okay, great. Right, so the state of play is complicated. Court watchers know that the Supreme Court decided in the Rucho case, the North Carolina case that they heard last year, to step away from talking about partisan gerrymandering in federal courts. But there's a lot going on and a lot packed into that, and many other venues where that partisan gerrymandering fight is still being fought. And there are many other kinds of concerns about redistricting, including racial gerrymandering. So maybe I'll use a few slides to say a little bit about the kind of work that I do that's connected to that and where I think the state of play is. Right, okay. So this slide called Spotting Gerrymanders in the Wild. So what you see here is 8 Pennsylvanias. So you see Pennsylvania divided into 18 congressional districts in 8 different ways. And so now imagine you are, let us say, the governor of Pennsylvania, and there's a challenge.
And your name is Tom Wolf.
And let's say your name is Tom Wolf. And there's a challenge in state court to the map that was put forward by, in this case, the Republican-controlled legislature in 2011. And now a bunch more maps are being proposed, and you need to understand what's a reasonable map and what isn't. And the 8 that I have here are 8 actual maps that were kind of on the table in 2018 when this came up. One of them is the notorious map that was being replaced. That's at the bottom right, and you can sort of see the shapes look a little crazy. And then the others were all other proposals out there at the time made by people. And if you look at them, I think you may agree with my takeaway, which is your eyeballs will not tell you much about these maps, right? So if we're thinking about the surgical precision that we heard about from Dale and from Anita earlier, we associate that in gerrymandering with lines that are really precision drawn, you know, cut with a scalpel to get you the outcome that you want. And so that map at the lower right, you might indict, and the others you might not know quite what to think about. So if you have a veto and you have to make a decision, you have to decide which of these maps are fair and which aren't, you might want to know what to compare them to, right? And so this is this computing intervention that I kind of mentioned earlier. You might want to use a computer, say, to draw you 1,000 comparator maps, or 10,000, a million, or a billion. And you might want to do that in such a way that the maps are built to conform to the rules. And so they're sort of neutral to everything that's not stated in the rules, and see what their properties are. So if we can go to the next slide, here's what that might look like. So this is an actual, remember my dissertation with the random walks on donut space? Well, it turns out that same math can random walk you around Pennsylvania's possible congressional plans. And so what's happening here live is a Markov chain is producing a lot of different districting plans that follow the rules set forth, that ex ante framework of the redistricting rules in Pennsylvania. And if you do this enough and you collect enough plans, the idea is it gives you this baseline of normalcy of the non-gerrymandered state of affairs, right? And I want to emphasize the reason that this is potentially interesting is that courts in particular have asked this question for years. I mean, at least since Justice Frankfurter, not only in 62 in Baker v. Carr, but earlier in Colgrove in the 40s already, the court was asking what's normal when it comes to redistricting? What does an undiluted vote look like, right? And so the hope here, the technological optimistic promise is that maybe this can answer that question. Let's go to the next slide. And so I think what we'd like to ask ourselves is, when it comes to gerrymandering, does this beat the eyeball test? Does this do what the kind of squiggle analysis can't, and tell us something about what we might expect? So the next slide, we'll take that question and that technique and go back to North Carolina, where you were already hearing about this map from 2012 and some of its replacements. So a little bit like the Pennsylvania situation, here you've got a notorious looking map from 2012. And then the legislature comes back with a new map in 2016. That's at your bottom right, and it looks a whole lot better. Nothing surgical about its appearance. But to the left of that is a map that was drawn by a bipartisan panel of retired judges in a kind of what some people call a shadow commission, trying to model what would happen if, instead of a partisan controlled legislature, if a more independent group were to make the plan. And again, I think if you look at these, your eyeballs will not tell you much about the judge's plan versus the legislature do-over. But now we can go to the last slide for the punchline. So it's a 13 district plan, and the folks who controlled the process were very open about saying, we tried to get a 10-3 Republican map, and we only stopped there because we didn't know how to get to 11-2. And so this slide just shows you what surgical precision looks like when you have a big batch of plans to compare to. So the bell curves that you're looking at are 100,000 alternative plans drawn just according to the rules. And what you're looking at is the Democratic share by district. So what would you do if you were trying to get a 10-3 map? In the third strongest district for Democrats, you might just jam it, pack it full of Democrats. This is called packing in the redistricting lingo. And so you can see where most plans were, and then those two plans from the legislature, outliers, lots and lots of Democrats, and the judge's plan kind of hitting the bulk of the curve. And then on the other hand, what would you do in the next district? You'd try to make sure there weren't as many Democrats in it. So you see the dots for the two legislature plans have much fewer Democrats, about 45%, not enough to win the district, not enough to be terribly close, while most neutral plans and the judge's plan have considerably more, and in particular have a Democratic win most of the time. Okay, so all to say, these techniques are still maturing. We have to be really careful about how we use them. Computers aren't going to be making the decisions for us. But what they can do, the promise here, the potential, is to give you that baseline of trying to understand an undiluted vote. When it comes to just balancing population across districts, the math is fairly simple. Try to have the same number of people in each district, although these days, the question, which people count, is also very foremost on our minds. But techniques like these can help you do what is invisible to the naked eye, which is to understand how something performs against a comparator ensemble of alternatives. And I hope that I'm here as a representative of a community of people who are technologically minded, who want to be doing that work in concert with you, with attorneys, with some of the best thinkers about fairness. The computers can't tell us fairness, they can't find it for us, but they can show us something about the universe of alternatives. And I hope that that's an important part of where we are now in the redistricting conversation.
Thank you, Moon. And it is part of the public record that Moon was a consultant to Governor Wolf, and lest anyone think that this doesn't matter, there are now, as of 2018, there were 4 new women in the Congress representing Pennsylvania than there were before as a result of the redistricting.
It was kind of interesting. There were none before. It was a 18-person all-male delegation before the 2018.
Not that gender was necessarily taken account of, but that was a good thing. Michael, do you want to talk a little bit about your perspective on gerrymandering?
Sure. So as Moon mentioned, there were obviously very disappointing losses at the U.S. Supreme Court, with the U.S. Supreme Court saying that partisan gerrymandering was a political question and one that federal courts should not get involved in. But the good news is that the war on gerrymandering has always been a multi-front war, one of which was in the federal courts. But and the good news is that on those other fronts, other than for federal courts, the war is going really well. So at least for the short term, there's a lot of reasons to be positive that the next cycle of redistricting will be better. And that includes some of the other fronts include winning reforms at the state level through ballot initiatives. Some of it is trying to pass reforms through legislatures. Another is litigation in state court. And there have been a couple of cases there in North Carolina and Pennsylvania where maps have been redrawn for partisan gerrymandering because state courts, rather than federal courts, struck them down under their state constitutions. And the fourth thing is political wins. So, for example, in Wisconsin, which had horrible gerrymandering in 2011, you now have a Democratic governor in Wisconsin who can simply veto an aggressive gerrymander. Now, that could change in the next cycle of redistricting. So that's unlike reforms, that's not permanent, but at least for the cycle of redistricting that will take place in 2021, there's lots of reasons to believe that a state like Wisconsin that now has a Democratic governor who can veto plans, and the effect of that veto will be to kick the map drawing over to a court, that the process will be fairer because we know that, courts don't always get the maps perfect, and there's a lot of room for arguing that courts could have done better. Courts also don't aggressively gerrymander either for racial or for partisan purposes, right? They may not get it exactly right, but they're in the ballpark. And so, the good news is that, gerrymandering, is a huge problem. And it was a huge problem in 2011. But this next cycle looks better. And I want to talk a little bit in particular about some of the reforms that have passed, because a record 5 states passed some form of redistricting reform in 2018. You have independent commissions now in Michigan and Colorado, and Michigan stands out because it also was one of the states that had really aggressive gerrymandering. In Ohio, you had reforms passed to the process and how you pass a map. And Ohio is another state that had really aggressive gerrymandering. And then you have also reforms in Missouri and Utah. And if you add to that New York, which passed reforms in 2014, that's 6 states since the maps were last redrawn that will have improved redistricting processes that at least should prevent like the most extreme forms of gerrymandering. They bear monitoring to see like which do better and how we can improve the process going forward. And I'll close just by also mentioning that there is another avenue for reform which isn't available right now, but that could be available next year, and that is that Congress has the power under the Elections Clause to, at least with regard to congressional redistricting, to establish uniform rules for how the redistricting process works, perhaps to implement independent commissions, although there's not enough time really to do that for this cycle, but Congress at least could create uniform rules for how congressional districts are drawn. It could create a statutory rather than a constitutional ban on partisan gerrymandering, which would give people an avenue in federal court. And so that was included in reforms that passed Congress in 2019. The Senate, or not passed Congress, passed the House in 2019. Those reforms have, of course, been sitting in the Senate because Mitch McConnell won't do anything with them. But if you had a different Senate and a different Congress and a president who was amenable to the reforms, you still could pass something in time for redistricting in 2021 because the good news is that it's likely that redistricting will take place later in 2021 than it normally does because the redistricting data will just come out later because of the delays in the census. So most states will not start redistricting until the fall of 2021 when they normally would have done it in the late winter, spring. So that gives Congress a chance to pass some legislation that could have a huge impact on redistricting in 2021.
Thank you, Michael. And while we're looking at what reforms are possible and trying to be more not only hopeful, but constructive, or at least focus our attention. Razan, I'm wondering if you could talk about what you see as the most promising and important reforms that are involving grassroots advocacy that would expand and protect voting rights. I'm thinking of initiatives like same-day registration or no excuse absentee voting or universal enfranchisement, others that you might want to point out. But where are the reforms that you think will matter the most that are being supported at a grassroots level?
I think one of the most important reforms is expansion of no excuse absentee voting, increasing the ability of individuals to participate in the process, free from the constraints of all of life, of the various factors that impact a person's ability to make it to the polls is something that is oftentimes very complicated. And if we are enabling people to get access to voting through the mail, I think that just increases turnout. We noticed here in Massachusetts, we had a record-setting primary turnout where the previous record was 1.5 million people who turned out for a primary election. And this past election, we had 1.7 million people participate in the election. And that is in part because we expanded our absentee voting to include people who were complying with the COVID-19 stay-at-home orders as being deemed physically disabled for the purposes of casting an absentee ballot. And I think that's something that is very significant, especially when you think about historically marginalized and disenfranchised communities. Early voting was increased as well here, and that is something that has significant ties to increased voter participation in Black communities, Latinx communities, and poor communities. And there has always been a groundswell of grassroots activism and activity around those. I think it was Dale who mentioned the kind of Souls to the Polls initiatives that Black churches would participate in by driving their members to the polls on those early voting days that included Sundays. so I think that is a very important reform. Automatic voter registration is particularly key. The more we facilitate people's engagement in this process, the better results we'll get. And through automatic voter registration, that increases the likelihood that people are going to participate. Pre-registration for 16 and 17-year-olds is another important reform that is necessary. And going back a little bit just to the automatic voter registration, I think one of the places, normally that what we're doing here in Massachusetts is the registry of motor vehicles when people apply for their license or state ID. But when we think about the National Voter Registration Act, where it requires voter registration opportunities for people who are on public assistance when either they recertify for their benefits or change their address, those are also places that need to be providing automatic voter registration opportunities, but also for people who are being released from incarceration. We release people after having served however many number of months or years or decades and expect them to be on their feet and successfully reintegrate back into society. And in states where there are not felon disenfranchisement laws, trust that they will just have a knowledge of the system and go out and register and participate. So, creating greater access through automatic voter registration for people who are returning from prison and jails, I think is important, but also expanding beyond that. And when we talk about grassroots-led movements, we have to look at Florida as the example of the elimination of felon disenfranchisement. To think of the connection and the timing of these felon disenfranchisement laws to correspond with Reconstruction, it makes a very clear statement about how racism continues to operate in the systems, and we'll call it structural racism. But then expanding that enfranchisement to move beyond people who have been released from incarceration, but include people who are incarcerated. Massachusetts and Maine and Vermont, I believe, were the three states that allowed people who were incarcerated to vote. And it's no coincidence that, Maine and Vermont are two of the states that still have it, and they're two of the widest states. Massachusetts eliminated voting for people who were incarcerated back in 2000. So it's not like this radical idea to let people who are incarcerated vote. But if we really want to have full engagement, really want to encourage people to reintegrate back into society and be successful members of society, I think it's important to expand the franchise to even people who are incarcerated. So those are some of the important efforts that will protect.
Thank you, Rasan. We're running very short of time. I'm not sure we're going to have time for a lot of questions. If anybody has a question or two, we want to put it in the chat room, that would be great. But I would like to go back to where we started and ask Justice Earls if you could just talk a little bit about the role of the courts going forward, how the courts might become a better vehicle for protecting fundamental voting rights. And I'll ask you to be a little brief, and then if we have a moment, maybe we'll have time for a question. But I see our chair is on the screen, so we'll see about that. But go ahead, Justice Earl.
Well, thank you. Very briefly, the Supreme Court did leave open that state courts can rule in partisan gerrymandering cases. And so what I hope is that as districts are redrawn following the 2020 census, that litigants will keep in mind that state courts and state constitutions can be a very robust protection for the right to vote. And I think what I would urge people to be strategic about is the fact there are real benefits and limitations. So litigants illustrate issues in an incredibly compelling way when cases are presented to courts. But sometimes remedies are challenging. Courts move more slowly. Lawsuits are really costly. And it can be extremely hard on election day to use the court system to protect the right to vote. And so as you think about what mechanisms we need to have in place, I think courts play a crucial role, but we have to be strategic.
Thank you very much. I'm going to turn it back to Nani Burns, but I just want to thank each of the panelists and I think we've had an amazingly rich conversation about these issues. We've covered a lot of territory. We could have kept going. We had some territory we didn't cover. But thanks to each of you. And Nani, over to you.
Thank you very much, Alan. And thanks to all of the panelists. Thanks, Alan, for moderating and managing a group of people who have a lot to say. And I want to thank the other participants, COSTAS PANAGOPOULOS, who we heard first off, and Dale Ho, who gave us really the soup to nuts history of the voting rights battleground. I think that one thing that we have learned here is that we have the structural underpinnings now for educating voters about how voting rights work and how the system works. And I do think that communications about that is really important in order to have people trust the outcome of the election and not be suspicious because it takes a while to count the votes, they don't come in right away or whatever, that we really do now have the knowledge to be able to explain to people why this process is complicated and why it takes a while, but that doesn't mean it's illegitimate. I would also, I must thank the staff. I know people say that sometimes kind of routinely. This is not routine. This conference would not have happened without the staff. Miel and Jennifer and Megan, from beginning to this very moment, have been really engaged and helpful and thoughtful and substantive and terrific nags to make sure that we all do our jobs right. So I really am very grateful to them. And I'm grateful to all of you, the participants who've come to listen to these experts. And I hope that you will join us in the networking event. I've never actually been to a virtual networking event, but we'll see how it works. And the link should be on your screen. And you have to, that's a separate Zoom event, but I hope we will all reconvene there. And thank you all, everybody, for a tremendously successful panel. I appreciate it. Bye.